My name is Jennifer Kuyrkendall Griffin. I'm running for Suwannee County Judge. In today's installment of Scales, or Suwannee County Access to Legal Education series, I'm discussing one of the most common types of estates, which is summary administration. Summary administration is defined in Florida Statute 735.201. If the decedent dies with a will, that's called testate estate. The survivors may proceed with a summary administration if the will does not direct administration as required by Chapter 733. Now, I can tell you nearly all of the wills that I've reviewed as general magistrate do not direct formal administration. There are two ways to qualify for summary administration. The first is if the value of the entire estate subject to administration, less the value of property exempt from the claims of creditors, cannot exceed $75,000. The second way is if the decedent has been dead for more than 2 years. So, an example of an estate that qualifies for summary administration is where the decedent had a house where he lived, which is protected from the claims of creditors as homestead, a truck that he drove on a regular basis, and household furniture and some bank accounts. But the bank accounts don't exceed that $75,000 threshold. So the home could be worth lots of money and still be protected from the claims of creditors, thus it doesn't count towards the $75,000. It's homestead. I'm going to do a separate presentation about homestead and exempt property, but for here, we're going to say the vehicle and up to $20,000 of the household goods are exempt. So in this example, the only thing that counts towards the $75,000 threshold is going to be the bank accounts. Now, this example also assumes that the heir is somebody that qualifies to receive exempt property, and I'll talk about that in the exempt property video. If the dollar threshold exceeds what is allowed for disposition of personal property without administration, then summary administration is usually what's used. Now, you're not required to be represented by counsel for any of the types of estates that we have discussed so far, including summary administration, but it's always a good idea to seek the advice of counsel. And if you'd like to look at the relevant statutes and rule applicable to a summary administration, it's going to be 735.201 through 2063 and then 5.530. And I'll tell you, on a petition for summary administration, the most common mistake that I see people make, including attorneys, is regarding the statement regarding creditors. You have to state either that the estate is not indebted or ultimately make provision for the payment of the creditors in the petition and in the order. This has been a broad overview of what summary administration is. Next week, I'm going to discuss formal administration, which is for larger, more complicated estates. If you found this information useful or you know somebody that could benefit from it, please like and share and follow the campaign on social media. If you have a particular topic that you'd like me to address, send a message through the campaign's website or social media, and I'd be happy to film a video for you. Just remember that I can't speak about a specific case or your specific facts, but I can speak in an educational manner. And if you ever miss an installment of Scales, please visit the campaign website to see all of the Scales videos that are available. And remember, on August 23rd of 2022, I'm asking you to vote for me, Jennifer Kuyrkendall Griffin, for Suwannee County Judge.